Hello everybody, it's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to teach you a little constitutional law and to answer the following question. Does the U.S. Constitution allow for plural office holding at the federal level? This is a question that lots of people have assumptions on, as you might expect, but often reach the wrong conclusion, all right? The natural answer to this question would be no. All right? As in our time, holding multiple political offices is something which is not only ethically unacceptable, but is something that is simply against the law in many U.S. jurisdictions. All right? The U.S. Constitution, however, ladies and gentlemen, is a different animal. When that document was written in the summer of 1787 in Philadelphia, the concept of plural office holding was anything but strange, okay? Not only was it common, but it was also widely accepted among the American people. Rarely was it prohibited. Individuals often served in legislatures as well as held judicial office at the same time, something we can't remotely think possible today. All right. Also, individuals also served in executive roles and performed judicial duties at that time, both concurrently. All right. Of course, while he was acting in a judicial capacity, he wasn't acting in his gubernatorial status, but you get my drift. The person held judicial office and role as well as role as a governor. All right. I mean, that type of thing today is completely beyond our purview. But back then, it was not only in existence, but accepted in many places. All right. So individuals often served in plural roles. All right. Something we can't imagine today and digest, without a lot of heartburn. You have to remember, folks, times were very different. And as such, the United States Constitution does indeed allow for plural office holding at the federal level. AKA, you can hold more than one federal office at the same time, folks. The U.S. Constitution only speaks on this subject one time and only prohibits plural office holding in very limited instances. Outside of that, it's fair game, all right? The one provision of the U.S. Constitution which speaks on this subject at all is known as the Ineligibility Clause, and it only targets members of Congress, all right? The Ineligibility Clause is located in Article 1, Section 6, Clause 2 of the United States Constitution, and it is often also known as the Emoluments Clause, the Incompatibility Clause, and the Sinecure Clause, all right? And it reads as follows. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. End quote. Simply put, folks, in exclusively targeting members of Congress, the House of Representatives, and the Senate, the Ineligibility Clause does two specific things. First, it prohibits incumbent members of Congress from holding any other office established by the federal government while they are serving in Congress. All right? So they cannot create this office and then be appointed to it. Disallowed under the Ineligibility Clause. All right? Second, it prohibits federal officials who are presently serving in either the executive or judicial branches of the government from simultaneously serving as a member of either house of Congress. So basically, it prohibits a member of Congress from also serving as a member of the executive or judicial branches of the federal government. Pretty straightforward, right? Good. Now that we've got that understood and cleared, these provisions were designed as anti-corruption devices, all right? As Congress was seen as the most politically vulnerable branch of the federal government to outside corruption, to money, to the executive, to lots of different things, okay? And the clause also had the purposes of maintaining the distinct separation of powers between our three branches of government, executive, legislative, and judicial, all right? And to discourage Congress from creating higher paid federal offices to which some of these members of Congress would likely be appointed to. So the framers were 10 steps ahead of that. in putting the ineligibility clause in the document. So, while these prohibitions do not allow members of Congress to concurrently hold executive or judicial branch offices, neither that clause nor any other provision of the Constitution has similar restrictions on individuals concurrently holding plural offices in the executive and judicial branches of government. All right? Additionally, while it may be prohibited under state law, neither the ineligibility clause nor any other provision of the Constitution bars individuals from serving, all right, as, a member of any branch of the federal government concurrently with an office at the state or local level either, all right? So the ineligibility clause doesn't affect a member of Congress or a member of the federal judicial branch or executive branch from serving and holding a state office as well, all right? Now, again, a state law might prohibit that, but there is no part of the Constitution which disallows such an action, all right? So that being said, the Constitution is a very flexible document when it comes to plural office holding, a true reflection of the era in which it was written, all right? And while it is technically legally possible for individuals to hold plural offices, as mentioned above, ethically, it is not something that would be viewed in a positive light in our time, folks. So again, perhaps the greatest example of this was Chief Justice John Marshall, who served as America's fourth Chief Justice from February 1801 until his death in July of 1835. He was the longest serving Chief Justice in American history, all right? Marshall was already Secretary of State under President John Adams when he was appointed Chief Justice of the United States in February of 1801, 1 month before John Adams left the presidency. He continued to serve in both of these offices at the same time until his time as Secretary of State ended with the close of the Adams presidency on March the 4th, 1801, with no questions asked, okay? No person since Marshall has ever held direct, plural executive branch and judicial branch offices concurrently, all right? In later years, loose examples were found with U.S. Supreme Court Justice Robert H. Jackson being appointed by President Truman to serve as a special prosecutor during the Nuremberg trials after World War II in 1945. Similarly, Chief Justice Earl Warren was tapped by President Lyndon B. Johnson in 1964 to chair what would become the famous Warren Commission that investigated the assassination of President Kennedy. All right? Both of these men continue to serve on the Supreme Court along with these extrajudicial activities, folks. My point is simple. It has been done and is technically legal, but in the modern era, our time, these things would not likely be repeated, okay? Therefore, the Constitution of the United States does indeed legally allow plural office holding at the federal level with only limited restrictions. While it is legal and while it can be done, in the modern era, it is very unlikely to be done. So I thank you so much for watching this video. I hope you've learned something, and I hope I might have answered any questions you might have had. If you have more, please leave them down below in the comments, and I will be happy to answer them for you. Take care of yourself, stay safe out there, never stop learning, and I'll talk to you at the next video. Professor out.